new members. We're happy to have you join us. So turning to the first item on the agenda, it's the acceptance of the minutes from the January 31st, 2022 meeting. I'll entertain a motion.
So moved, Judge Bellis.
Thank you. Is there a second? Judge Albus, I think you might have been seconding, but your microphone is off.
It was off. It's on now. I'll second. Thank you.
Thank you. Is there any discussion? All those in favor, please signify by saying aye.
Aye.
Aye. Any opposed or abstentions?
I abstain. Judge Knox.
So noted to the new members. Understood. Thank you.
Judge Morgan
so-
also abstains.
Okay, thank you, Judge Morgan. So turning to the second item on the agenda, it is a referral from the Rules Committee. I don't think there's an actual proposed rule, but a concept, if I'm not mistaken. And I think Judge Bellis and Judge Albus have reviewed this along with PJ Deek. And maybe you could walk us through what the proposal is and we can have a discussion, if that sounds okay to everyone.
Judge Albus, you want to take the lead on this since it's a family issue, although we were both
Sure.
on the working group committee?
Sure. There was a proposal to the Rules Committee from a family law practitioner that the current files that are still in paper form, primarily because they're old and predated e-filing in family, be converted upon request to e-files going forward. And the Rules Committee had asked Judge Bellis and me to form a working group to discuss with attorneys about this. But she and I both agreed it made more sense to come to this committee first because it's in many ways an operational matter, not so much a procedural matter. And we thought that if this committee believed this either couldn't or shouldn't be done, it didn't make much sense to impose on the time of attorneys to ask what they thought. And that maybe our first step would be here and then to let the Rules Committee know what this group thought. And I know, Judge Bellis, you had a conversation, I think, with PJ about the statistics that appear in our agenda and the fact that going back before my time on this committee for years, it's always been felt it was not worth the resources to start trying to turn paper files into electronic files, and that this is a problem that's going away gradually over time as the kids in those cases reach age 18 or 23, as the case may be, or alimony orders end, and that paper files are becoming less and less common anyway. But we wanted to bring this to this committee. And Judge Bellis may want to add something as well as PJ.
Yeah, I think just briefly, I think PJ has the institutional knowledge, as do I, since I recall specifically when we vetted the issue the first time about whether we would have family files be hybrid files where you could e-file and paper files. And it was a lot of time was put into it, and we made the determination that it was such a big build and that it would be very difficult to do it. And I don't think anything's changed. And now, because of the diminishing returns, there are so many less files in existence. I think it would be even, just we wouldn't get the return on the investment, the time that it would take to build it. So, but I would, defer to PJ on that issue, of course.
Okay. Certainly the data suggests that the number of events being scheduled in court for paper family files has been decreasing steadily over the years. Back in 2008, if we look particularly at dissolutions of marriage, there was something like 16% of the events scheduled in Edison were for paper files, and now we're down to 11%, and that percentage presumably will continue, as you both mentioned. It is a big, it's an underlying structural change in the e-filing system to do this. So there is a lot of, there would be resources needed to make the technological changes, time, and that would pull away from other projects. In addition, the upon request component creates, the Civil Family BPAT team met and discussed this from a business standpoint, creates complexity and confusion as to whether any particular case is hybrid or is not hybrid. And it also requires work then on the part of the clerks and perhaps even the judges to process or grant or whatever, however it is that someone would go about requesting and then having granted that their particular case becomes a hybrid. So all of those things I think lean in the same directions that you're leaning, which is that there are reasons not to go in this direction. In addition, historically, the Judges Advisory Committee in 2013, leading up to paperless family files, and 2014, shortly after family files began to be paperless, consistently advocated or voted in the direction of not making hybrid files in family, but having paper files be paper and electronic files be electronic. The same thing was then carried through into housing and small claims as they came on board with the e-filing system.
Thank you, PJ. Does anyone have any questions or anything further to add with respect to the suggested change to the e-filing system regarding old family paper files? So, I mean, what everyone has said, and I hear nothing different. It makes complete sense that the position that was originally held by this advisory committee remain intact, even more so now since, looking at the data, the decline of the number of paper files just continues to dwindle, and hopefully we'll have none in a very short order. So I would just suggest, unless I hear otherwise, that the proposal, for lack of a better word, I never saw an actual amended rule change, but be referred back to the Rules Committee, maybe with a brief notation that it was reconsidered again, because it was considered long ago. And the position of this advisory committee is still the same, that it just doesn't make sense to put that much effort into this kind of rebuild for very, very little return.
So I think Judge Albus and I, as the working group, can report back. And I don't know if you mentioned Judge Albus, but we did reach out to Judge Diana, and Judge Diana is in agreement that it would not be worthwhile to pursue it. Is that fair to say?
Yes, and because originally this came up when I was still the family CAJ, it'll probably be Judge Diana who reports back on this. And I had filled him in on the proposal, but I also asked specifically as far as what this committee would be doing if he agreed with Judge Bellis and me, both on this item and on the next one, which also has to do with family. And he was in full agreement with our positions on both the items.
Okay, so we'll report back then to the Rules Committee. Perfect. Thank you so much.
Thanks so much. So as you mentioned, Judge Albus, we'll move on to the third item on the agenda, which is another request or referral from the Rules Committee to grant members of the bar online access to family cases via e-services when they don't have an appearance in the file. So did you guys discuss this at your work group as well?
Well, we discussed it with each other, and we thought, again, the best first step before talking to practitioners was to come to this committee. This was a proposal by the same attorney who proposed the previous item. And just for judges who may not have served in family or other members of the committee, the way it works now, and PJ or Judge Bellis can correct me if I'm wrong, unlike a civil case where any member of the public can go online and see the list of items filed and open up the documents and look at them, in family, because of some special concerns about the effect on children and families, the branch has always taken sort of a balanced approach, which is that if you don't have an appearance in the case and you're not a party to the case, you can go online from anywhere, see the basic case information, see the list of pleadings and orders, but you cannot open the documents. That if you want to see the documents, you need to go to a courthouse, use the courthouse computer, just like you used to have to go to the courthouse to look at the physical file. And from the courthouse, from any courthouse in Connecticut, you could look at any electronic file, including its contents in the state. The proposal would be to allow attorneys only to view the contents of files from anywhere, whether or not they had an appearance in the case. And the example the attorney who proposed this gave was, if a client comes to him and seeks his help in a case, it would be helpful to him if he could view the contents of the file without having to spend the time to go to the court to look at the file on the computer there. Otherwise, but members of the public would have no greater access than they do now. And our feeling in speaking with each other, and Judge Diana concurred, is that first of all, I've always avoided having rules that allow attorneys to do things that self-reps can't do. And we still think the reasons that we had a more limited access to family files can apply whether it's an attorney looking at it or not. And that if someone's a family practitioner, our feeling was they'll be in some courthouse frequently enough, especially now that all the courthouses are open. It's not like during COVID, which was at the end of COVID when this was presented to the committee, that the attorney should have ample opportunity to take a look at other files on the courthouse computer when they happen to be there on another case. And we were not really in favor of opening up the files to anyone who has an attorney license in Connecticut, whether or not they really had a direct interest in the case from their office or from their home. Judge Bellis, anything I omitted from our discussion?
I think you covered everything perfectly.
And Judge Albus, just to make it clear, in the event there's anyone from the public who's viewing, any lawyer could go into a courthouse anywhere, say, for example, in Hartford, and view any file from anywhere in the state. Could view a Stanford family case, a Norwich family case from a Hartford location. That's true?
That's true. And that's true for a member of the public too. You don't have to be an attorney.
Well, can I just clarify if you don't mind? So,
yes,
right from anywhere at home, any computer, you can still see, as Judge Albus said before, all the attorneys, all the events, all the pleadings. You can see everything that's been filed. The only thing you can't do is click on and open the pleading. So you still can see if the case is a particularly active case, what events are scheduled. You can really see, you get a very good flavor of the case from any computer at any time. And as Judge Albus pointed out, if you want to actually click on a pleading and read it, if you don't have an appearance in the file, you can go to any courthouse, even a GA down the street. And I think the point is, since the reason for this, the special access for attorneys, which we were opposed to, is, when they're considering a new client, they're already going to be in some courthouse for another case, and they easily can look. So we didn't think it merited giving special access to non-appearing attorneys.
Anyone have any questions or any further discussion with respect to this item on the agenda? Hearing none, may I impose upon you again to get back to the Rules Committee with respect to this advisory committee's position on that proposal?
We will do that. Thank you.
Great, thank you.
Thank you very much.
So let's see, turning to item number 4 on the agenda, the status of CVFA e-filing project and upcoming releases. PJ, anything to report?
So just briefly, one thing that we've just completed that's going to go live on Friday is functionality for the family courts like the J-file prep and the JDF 170 prep screen. We've created a process with Judge Albus's guidance and Judge Diana's involvement for uncontested dissolutions that don't involve a hearing. The clerk and the judge are both able to work with those prep screens in order to process and prepare an order more efficiently for those. A couple things that are upcoming. We're working on expanding integration between the Edison system and Remote Justice, which is the system that JIS has for holding remote events. We're looking to make changes for next July to the way summary process cases are displayed on the internet. That's a statutory requirement. And we're also in the midst of a complete rewrite of Edison from the ground up so that it's sustainable and resilient into the future. It's scary to say, but the language and the platform it's built on now are now legacy. It's a legacy system. It's 23+ years old, and it needs to be rewritten in order to be sustained into the future. The last two things that we're also working on that are of note are data feeds and data sharing with other systems within judicial and with the executive branch, so that CSSD's CMIS system will be able to have a limited set of data on family cases so that they can keep track of when events get moved or when new things get filed on a case that they're involved in, family relations is. And the other is with the CSIS system, which is maintained by DSS, but also SES. So it has sort of a cross-branch existence. Right now, we feed PDFs of the family support magistrate orders to DSS. We're looking to expand that to include data so that with their new system, they can populate certain fields in their system with data from us directly, rather than needing to data enter everything all over again from the PDF of the order. So those are both fairly progressive moves.
Sounds great. Thank you. Thank you, PJ. Does anyone have any questions for PJ? No? Okay. So the last time on the agenda is establishing a meeting schedule. The intention is to meet quarterly, and of course, if there's nothing that needs to be discussed, we could always cancel it. And instead of trying to kind of pick out dates with this many people on screen or on the committee, I'm going to suggest that we'll, throw out dates for quarterly dates starting in January. Thinking that afternoons are usually probably better for the judges. And I'm not sure if there's a particular day of the week that's better than another. Today's Wednesday. I don't know, late Wednesday afternoons. We could pick out 4 dates going forward. If no one has any objection to that or any particular preference with respect to a meeting date. Does that sound okay? All right, I hear no objection. So I'm going to assume that that will be acceptable, and we'll get those dates out to you sooner as opposed to later so you can plan accordingly. Thank you, everyone, for attending today.
Thank you.
Thank you, Your Honor.
Thank you very much.